I filed an objection to late pleading, though that somewhat pro forma indicates a request that the court strike any pleadings that were filed late, given that Ms. Davis is pro se. I think the court's more likely to continue. So I'd ask that it be set over 2 weeks so that we can respond. My client filed a temporary restraining order petition that was signed ex parte by Your Honor. It was on in front of retired Judge Warning on the pro se docket, was put over to today because nothing had been filed by Ms. Davis. She filed on the 9th and served us on the 10th just last week. We were unable to file a response for the court, but my client has information that he's compiled for filing that we should have to the court by the end of this week. I know next week is closed or full, so I'd ask it be over 2 weeks.
Ms. Davis, any response?
No, that's fine.
Is there, is there a temporary restraining order that needs to be extended?
Yes, Your Honor, there should be. There was one granted that was indicated on the record by Judge Warning. He couldn't do anything today, couldn't do anything because there was no response, set it over to today, requested that be extended. I couldn't see in Odyssey whether that had been done or not. I can prepare one if Your Honor needs an order extending the temporary to the next hearing date. It really just protects property. That's part of what my client's going to be providing in this declaration, that some of the items that Ms. Davis already had in her possession have potentially been sold in violation of that restraint. So my client wants to make sure that restraint provision continues.
No, actually, that was
Ms. Davis,
also
that's not how this works. Ms. Davis, we don't interrupt people in court. I'm sorry, we don't do that. So please refrain from interrupting anyone. Mr. Baldwin, go ahead.
Yes, Your Honor. I was just indicating that that's information my client's provided that will be included in this declaration. So we want the restraint provision to continue. It was granted by the court on a temporary basis and should continue until the hearing is able to be held.
All right, Ms. Davis, if you disagree with that assertion, by all means, you can file whatever you want to prove your position. I will, given the late pleadings and kind of the layered issues that we have, I will set this over. I do have room on my docket the 31st, if both parties feel that's enough time. And are you available on the 31st?
Yes.
Okay. So we'll set this to the October 31st, Tuesday, 1:00 p.m. And if Mr. Baldwin, you want to send an order extending ex parte, I will sign off on that as soon as I receive it.
Thank you, Judge.
All right. So, and that means, Ms. Davis, basically that everything's remaining status quo until we come back on the 31st.
Okay, and what time on the 31st?
1:00 p.m. Same as.
Okay.
Okay.
That matter's ready, Your Honor.
All right. Good afternoon. So I have this on for presentation of orders. I don't know. Let's see here.
Your Honor should have 2 orders, one from each of us and a transcript.
I have one physical copy of a parenting plan from Ms. Winkles. I did see the filed parenting plan from Ms. Ernest, and I did see the filed transcript. So where are we at?
I would be happy with Your Honor reviewing the transcript and just deciding what this parenting plan is and letting us know at a different date, hopefully sooner than later, rather than argue, because Your Honor is the only one that can decide what needs to be on there. So I have no problem with that if Ms. Ernest doesn't either.
I have no problem with that. And I will add that this is the first time in this case that there has been a Form 140 at all. Everything else until this point has been like hodgepodge bench orders. I think there was a temporary order that said that there was going to be some visitation, but it was a temporary family law order. So this is the first time we're looking at an actual formal plan. And I think that, yeah, I agree with Ms. Winkles though, and just having you decide.
Okay. I was supposed to be in trial all day tomorrow, and then that was struck because there was a resolution reached. So I actually have some time tomorrow, and I'll just, I guess, Miss Ernest, if you're willing to send a hard copy so I don't have to print off of Odyssey your proposed, and then I will just work off which one I think is closest, and then I'll make sure to email you both a copy of what I'm entering.
And does your honor want a physical copy of the transcripts as well? Because we actually got the transcripts from the hearing, you know? Okay.
Well, let me see. I might.
They're in Odyssey, but that you might just want a paper copy.
Those are for the 24th.
And I'm headed over the courthouse right after this, so I can drop whatever off if needed.
Okay. I'm fine reviewing those on Odyssey. Just having Ms. Ernest, your proposed parenting plan, a hard copy, clean hard copy that I can file if that's the route I choose would be great. If you could just drop one of those off this afternoon, and then I should be able to get it done tomorrow. And if not tomorrow, then I'll for sure this week.
All right, sounds good. Thank you, Your Honor.
Thank you.
All right.
Good afternoon, Your Honor. It's William Ball for the petitioner and Wolf.
Good afternoon. And I do see, it looks like we have Mr. Wolf here present. Mr. Wolf, you can hear us? You're muted, but it sounds like you're responding to us, so hopefully that means, there you go. Okay. All right. This was on, I think, last week, and it was set over to today. Where are we at today, Mr. Ball?
We had an agreement, and I think we have an agreement. I don't understand why we had to come and do this. I think it's a waste of the court's time. I think we're ready to settle, as we should have done a long time ago.
All
So
right.
I provided all the information I possibly can, and I really don't understand why we're here. I'm a little bit shocked. I thought we had this worked out.
All right,
So,
Mr. Ball.
Your Honor, discovery was issued on April 5th, and we had our CR26 conference on May 19th. No formal responses to the discovery have been provided. Mr. Wolf has provided some discovery documents as recently as this morning. I've been in communication with him about what I feel needs to be supplemented with regard to some of the documents. Your Honor, I'm asking for full and complete answers by October 24th, and the petitioner's attorney fees in an amount of $1,000. We have a settlement conference on the 26th, a judicial settlement conference. So I know last week
we should have settled this.
Mr. Wolf, if you didn't hear me before, we don't interrupt people on this docket.
I'm sorry.
I don't want to mute you. I don't want to get angry. So please, we have to be civil, one person at a time.
Okay.
All right. I apologize. Go ahead, Mr. Ball.
Your Honor, last week you said that the October 24th docket was closed, but we're asking that the responses be by October 24th in light of the settlement conference we have next week. Mr. Wolf is correct. We have been working on a settlement. We don't have it finalized yet. We're getting closer, but we still need things that we requested in this discovery response, which I feel are necessary. So thank you, Your Honor.
All right, go ahead, Mr. Wolf now.
Okay, well, yesterday I asked Mr. Ball if he had all the information that he needed, and he gave me a list of the items that he wanted, and then I've provided that to the best of my ability. There's some things that Anne has only access to that I haven't been able to get to this morning just because she didn't get me the code. You know, they send a security code to the cell phone. She has everything going to her phone. It's under her username and password. And she gave me the username and password, but I can't, she doesn't respond to me fast enough with the security code for me to get on there. So, I mean, we can do that in 10 minutes if she just needs to get back to me with the security code. So, you know, this has all been settled and blown way out of proportion. Anyway, I'm ready to settle today if we can just, you know, come to an agreement like I think we've come real close to. You know, this has gone on for a year when I think we could have settled initially, and that's what we were supposed to do. When I talked to Ann initially, is that we were going to settle without involving big attorney fees and the courts and everything, and just do. And I've always told her she would get everything she wanted, and I've always agreed to that. This has been non-contested. And somehow we've got, you know, she's run up a $20,000 attorney bill for a uncontested divorce. So that's my concern with that. So I'm ready to do whatever we need to do to move forward. I just feel all this is just unnecessary, and I've already provided everything that I can possibly provide. that I'm aware of.
All right, it seems like there's probably still some outstanding things. Mr.
Well,
Ball,
that's what I'm trying to figure
I'm
out.
talking now.
I'm sorry.
Talking now. It's, I'm assuming that Mr. Ball isn't, just sitting here lying to the court. That would be a pretty, serious ramifications for his job. So if there's still information that's outstanding, I will, grant his motion to compel. So that means, Mr. Ball, you need to make sure that you comply with the full discovery and all the different things. I will also say though, or excuse me, Mr. Wolf, Mr. Ball, I would ask that your client aid Mr. Wolf in getting some of this information. I'm frankly play that game with my husband all the time, trying to ensure that I have the activation, password on certain accounts. So I understand Mr. Wolf's position that his hands may be tied on some of this. Your request is that everything be submitted by today at 5 p.m.
That's what we had originally set this, a few weeks ago. So it's actually next October 24th at 5 p.m. When we submitted the order, we were asking for October 20%. I think that's a typo to begin with, Your Honor.
Okay. So, what I'm going to do is I'm just going to change this order a little bit. So I'm going to say that the 24th by 5 p.m., Mr. Wolf, you need to ensure that you've provided all the remaining discovery. And if you need to talk with Mr. Ball about specifically what that is,
I don't.
by all means do that.
Can I say something?
Sure.
Yeah. I mean, yesterday I asked specifically, is there anything that you need? I sent him an email and he responded with a list of things. And then today he sent me an email 10 minutes ago, right? So asking for something to do with my mother that I have no idea what that is. And as far as I know, it doesn't exist. So I'm just completely blown away. I've been trying to be totally cooperative and provide everything, which I have. And it's like all of a sudden creating something else that I don't even know what it is. So I just need a list of things that he wants, and I got no problem providing it, but I need to know what it is.
I guess, Mr. Ball, is that the most recent request? Is that the end of everything? Is there any additional things that you are aware of besides that most recent request?
Well, I'm asking him to respond to file a formal response to our discovery request with interrogatories and request for production of documents. If it's an answer that the petitioner has the documents or has access to the documents, then that's the answer. We'll provide them. But if there's other things that he has access to, which he just alluded to, that I don't have access to.
I don't have any idea what he's talking about. Is the problem? Find the email here. I could read it to you if you want. I don't know what he's talking about.
Well, you're not represented, Mr. Wolf, so you can.
And I'm trying to avoid that.
I understand that.
It's a $10,000
again, I'm talking.
I'm sorry.
You have an opportunity to have a conversation with Mr. Ball directly. So you can say, can you explain to me what you're asking for? And I will get it for you. The deadline will be 5 p.m. on the 24th of October. And we'll review this on the 31st of October at 1:00 p.m. If there is a settlement on October 26th and you want to strike that 31st date, that's perfectly fine. So if there's an agreement that's reached prior to that review date of the 31st, excellent. Feel free to strike this. I'm not awarding any attorney's fees as part of this. There's a significant amount of spousal support that's taking place, so I'm not awarding any attorney's fees. But I did make the changes, I believe, everywhere in this document to reflect discovery due October 24th by 5 p.m. and a review on the 31st, knowing that there's a settlement conference on October 26th. All right?
Okay, thank you, Your Honor.
Good luck.
Thank you.
I have Mr. Anagnostou here. Long story short, over the past week, Superior Court Administration has reached out to Mr. Anagnostou, provided the waiver the waiver of conflict. Mr. Anagnostou agreed to take the case back. I have an order reappointing you, Mr. Anagnostou. So basically you're starting fresh again, is my understanding, and speaking with Judge Basher. So I have an order reappointing and authorizing payment for services for Mr. Anagnostou in this case, that I will sign and enter today. I have Mr. Couch present, Ms. Ward's present. Do we have, are the property still in foreclosure, or did something happen?
I have somewhat of an answer for that, Your Honor. The property is still in foreclosure, and part of the problem. So I did a declaration, very short notice. I did it in a day, but my client had a plan for getting it out of foreclosure. Because this is still pending, his investors, don't want to put a bunch of money into the property just for him to be kicked off of it. And so I noticed at your last hearing, you said no grounds to order or sell a property if it was not in foreclosure. He needs an order to that effect. If we could get an order to that effect, his investors are ready to cure the default, which would stop the foreclosure, and he would just go back to making regular payments on the main part of it. It's income producing property. He's living on it. He wants to continue to stay there. And so because this has not gotten resolved, and because I was basically removed from the case 2 weeks ago, it has stayed in this unstable position. But if we had an order along the lines of your ruling last week that if the foreclosure was cured, then Mr. Couch could stay on the property. The court wouldn't have grounds for selling it. He could get that accomplished. I mean, that's what he's telling me. And I had conversations when I found out I was being reappointed. I talked to him. It was like 5 o'clock last night, and then I talked again this morning. And he said that's what the issue is that this hasn't been resolved. It continues to get kicked down the road. And he gave me a bunch of other facts as to why. I'm not sure if Your Honor wants to hear that, but that would be the easiest resolution at this point if we set this over a week and granted my client an order along the lines of your ruling last week that there would be no foreclosure. He would not be removed from the property if the court wouldn't have, you said, grounds, and the court wouldn't have grounds that he could stay on the property if the foreclosure wasn't pending, and then he would get the foreclosure satisfied. He's got like I said, the investors ready to go on that.
Ms. Ward?
So, Your Honor, we have stated repeatedly, number one, this has been pending for 3 months. We have stated repeatedly that the only reason we brought this motion is because he has not cured the default. He was on notice that the property was going to go into foreclosure if he did not make the required payments long before we ever brought this motion. Every time we come back before the court, he's offering more excuses, requesting more setovers. It doesn't make any sense that he wouldn't simply pay the amount owing to have this motion go away. Not only have we stated that we would voluntarily withdraw the motion if on the record, if he made the payment, but as counsel just stated, Your Honor stated that there wouldn't be any grounds for requiring it to be sold if he brought it out of foreclosure. That was also stated on the record. So to now come before the court to say, oh, we need it in writing that this is going to occur when it's already been stated on the record repeatedly, and Mr. Couch has known that if he didn't make the payments, it was going to go into foreclosure. It just seems like an opportunity to make this motion go away without any assurance that he's actually going to pay the amounts owed. Your Honor stated that at today's hearing, a decision was going to be made. Mr. Couch was on notice of that. And if he was going to be able to come up with the funds and make the payment, he would have done so by now. At this point, we're looking at November 3rd for a foreclosure. So my client at this point has very little opportunity, but would like to make the best of the opportunity to be able to sell the property, short of it simply going to a fire sale through foreclosure and there being no equity left for anyone. Again, this is the only asset remaining of any value in the case. And Mr. Couch has had ample opportunity to get it out of foreclosure if he had the means to do so.
Your Honor, if I could, I mean, I've gotten a lot of information from Mr. Couch just recently, but unable to get it before Your Honor. But if I could explain just kind of some background on what's going on. Mrs. Couch's brother, Matt Smith, is the president of Rush Companies. Rush Companies apparently is the party that paid paid for an appraisal, and they valued the property at 1.2 million. They currently owe about $1 million on it, so a little bit over what's owed on it. And so if there's anybody going to do a fire sale, it's Mrs. Couch, who's going to turn it over to her brother, and he's in this Rush Companies, and that's what they do, commercial real estate development, and they're going to get this property on a bargain. My client's real estate agent says it's worth at minimum 1.6 million. And my client can get this out of foreclosure if he had an order stopping them from bringing us into court every week. It's making everybody nervous that Your Honor is going to take the property away from him. And these investors don't want to give him the 70,000 to get it out of foreclosure. I mean, they say, he needs to get it out of foreclosure. Well, in order to do that, he's got to pay 70 grand. And he doesn't have 70 grand, but he can get 70 grand if this was a stable market right now with regards to this piece of property. It's very unstable. With every week we come back to court saying, we're going to take the property away from you. We're going to kick you off of it. We know you're living there. And he's trying to find investors in it, but he has assured me yet again, as he did 2 weeks ago when I was in the case, that he could get this accomplished if we could stop these motions from occurring. But the investors have indicated they could have that paid within the week. And if we had an order along the lines of what you said, that there was no grounds if we were out of foreclosure, so get it out of foreclosure and we would stop these motions.
Your Honor, 2 weeks ago,
Hold
they
on.
submitted.
I don't need to hear anymore.
Okay.
Here's where I'm at. I think Mr. Couch has been without counsel for a lot of these reviews, and I understand that he now is afforded counsel, and I appreciate you being here, Mr. Anagnostiu. We've been here every week because of Mr. Couch. So, and not because of Miss Couch or Miss Ward. We've been here every week because of Mr. Couch. This is what I'm willing to do. I'm going to set it to this Friday at 8:45 a.m. If it is not paid off, and I will enter an order, a bench order that says if the foreclosure is cured, there's no grounds to grant the motion to sell the property, period. I will sign off on that order, file it today with the documents as soon as I'm done with court. If it's not out of foreclosure Friday, I'm going to grant the motion. So 8:45 a.m. on Friday, Mr. Couch has had plenty of time. He indicated more than once that these are family and friends that are paying him. So this isn't some bank entity that needs an order. We've told him repeatedly that this motion would go away. There'd be no grounds for it. Ms. Ward has indicated that it would go away if this is paid off. We're down to the wire because of Mr. Couch. Understand, on the other hand, that we needed counsel for Mr. Couch. But frankly, we sit here because of his inactions, frankly. So he has until Friday morning at 8:45 to provide proof that the property is no longer in foreclosure, or I'm going to sign the order. That's where we're at. So Friday at 8:45 is the 20th of October. That's 8:45. That's my presentation docket. I'm in trial this Thursday and Friday jury trial, but I will make sure that we have time to hear from Mr. Couch Friday morning.
So just to clarify, Your Honor, we're setting this on the docket Friday morning at 8:45.
It's just, yeah, it's my presentation docket and it's a Zoom hearing just like this. It's not a regular docket. It just says Judge Fassett's presentations.
Okay, and does Your Honor still have a copy of our proposed order?
I do, and I will keep it with me.
Okay, and Your Honor, we would just ask that there be one line added, should it be granted, just asking that any additional contracts that he's entered into for the property since this motion's been pending, that those be set aside, if that is granted.
All right. So, and Mr. Anagnostou, should that, I guess, put you on notice for that as well. And I will keep a hold of this order. My hope is that I don't enter this order. I want Mr. Couch to understand that. I want him to figure this out. I understand how important this property is to him and his family. I also am very sympathetic to Ms. Couch's position because, you know, we shouldn't have to be here. So the 20th at 8:45. And Mr. Anagnostou, if there's late.
Yes, Your Honor, if counsel could forward me, I have no idea what the order says that we're looking at.
Your client has a copy. I've always provided him a copy of proposed orders, but I can send one as well, but he also has it and can provide it to you.
It might also, I feel like there was.
Have been filed.
I feel like it might be an Odyssey as well. And I think, let me just look, Mr. Anagnostou, because that may be the easiest for you. All right, 8:45 on the 20th. I will enter that bench order as soon as I'm done here. And then I'm gonna just, Madam Clerk, I'm gonna keep the order, Ms. Ward's order for Friday morning. For pre-trial.
Thank you so much.
And it looks to me like, sorry, very slow computer today. Looks to me like we are on for readiness the 31st of this month and trial the week of November 6th. Mr. Gall, you are the petitioner. Do you have any issues, concerns, things that need to be addressed today?
Yes, Your Honor. Good morning. Frankly, I'm surprised that this is happening. I was notified by the guardian ad litem at 11:30 this morning that there's a pretrial. That's the first I've ever heard about this, Your Honor. The last time that this attorney served me was 2 weeks ago with interrogatory paperwork that was requested a year and a half ago. So I'm a little shocked to be here. I had to rearrange my schedule, and I still don't know the rest of this trial information because I was not properly served. I'm happy to comply and get through this process. I just need to know what the rest of the dates are and when I can submit my talking points or my arguments.
And Your Honor, just a brief reply. It's not the attorney's office that serves Mr. Gall with the readiness hearing or any of these hearings to prepare. That would be the court emails it to both of us, as long as the email's on file, and it's up to us to make sure our emails are correct. It has nothing to do with me. I served him. We set the original trial date the week of, and we set these dates. I'd asked to go forward. We're both ready. We all have discovery. It's just a matter of time now to get the trial briefs in and our witness list.
Your Honor, may I respond?
Yes.
I appreciate that explanation, Ms. Winkles. I do not feel that I am ready. I had a second set of interrogatories that hadn't been returned to me yet. I just received your first set 2 weeks ago by your process server.
I have not received any second set of interrogatories from you. I've received a request for admissions, which were answered. I received interrogatories and requests for production, which were also answered. This case has been going on quite a long time. I believe it's we're hitting on 2 years now. We've had plenty of time to do discovery. The fact that Mr. Gall waited until after we've scheduled the trial is concerning. If he would get me that, I will. The November is the trial. It's the week of November 6th, if I'm correct.
November 6th.
If he can get me that discovery request by the end of today in my email, I'll have it to him well before that. I will try to get it in by Friday because this trial needs to go.
Okay. Lastly, Your Honor, I do have email documentation from my previous attorney stating that this matter was going to be sent to a negotiation rather than a trial. And that was the last time I heard from Ms. Winkle's office in reference to settling this matter. I'm happy to provide that as documentation and as additional support that there's been no communication from this office to me so that we can try to reach a settlement or an agreement or complete this process.
And Your Honor, just respond. My client, alleges that she's the victim of BV. We had the MSC waived. My client does not want to settle. My client would like to be in a Zoom courtroom with a judge making the final determination.
So, Mr. Gall, it does appear that your previous attorney signed off on an order waiving mandatory mediation back on March 28th of 2023. So
Waiving it?
that is correct.
Oh, okay. That's great to know.
Your attorney was Miss Margraf?
On Margraf was my last attorney. Yeah, unfortunately, she was too expensive for me, and my finances are running low. That's actually another question that I have for you, Your Honor, if I may. I know that I am pro se. I know that it's probably not advice, but unfortunately, my wallet doesn't allow it. Previously, during this matter, the court had decided that I be responsible for $1,100 of child support monthly. The state has been very proactive in maintaining that order. And I have been fighting my finances and all of mother's financial attacks through her attorney to try to stay afloat. I feel that the $500 that are left in my account every month isn't enough to cover for bills, food, or any additional expenses. I would like to submit all of that documentation for trial. Would that be appropriate, Your Honor?
So the first thing is I can't give legal advice. However, I will say anything that you want the judge to consider as part of your case for trial should be submitted by way of an exhibit at the time of trial. There are some rules and there's some insight provided on the Cowlitz County Superior Court webpage for if this is a Zoom trial, how you have to go about doing that. So there's some guidelines there that may be able to help. There's additionally services offered on Monday from noon to 2 on the second floor of the Hall of Justice. There's legal aid attorneys at volunteer time that you can ask, come into the courthouse, talk to about how exactly you would get that stuff together to present to the court. You can also reach out to Northwest Justice, which is a statewide low-income agency that works with people to do some of these things and sometimes can provide, just instead of actually representing you in a case, they can provide insight and information on how to do some of these things. So I would encourage you to reach out to those folks. But yes, there's a way that you can absolutely do that, and the court would be able to then take that into consideration.
Great. Thank you, Your Honor, for that. 2 more questions about pretrial and readiness, and I think I may be done.
Sure.
The next question is, can I subpoena people to testify during trial?
Yes.
Perfect. Okay. Subpoenas, good. And the last question is, custody. Actually, I think there's 2 more questions, but let me deal with custody. If custody is still being reviewed by the reunification counselor as ordered by the previous judge, I forget his name, would custody then continue to be an ongoing concern because it won't be, the reunification counselor does not have enough data by the date of trial?
That's a great question. I can't really answer that for you. Ideally, at trial, all matters would be resolved at that point in time. If there's a situation where there is reunification or some other ongoing counseling treatment services to any of the parties, the court would obviously need to know that, be aware of the timeframes around that, and it may impact the ultimate decision. So I can't really give you a solid answer on that, but that's definitely, I'm assuming both parties, that's something that they would want the court to consider.
Yeah, absolutely, Your Honor. So currently reunification has been delayed by mother for many reasons. And custody is definitely not set. It's not ready. Okay, and then the last question that just popped in my head is the home. That home needs to transfer so it can be uploaded and be out of this picture. That is also handled at trial, correct?
Correct. Trial would hopefully, as I stated, resolve any financial issues, property issues, child custody issues. All of that would ideally be resolved through trial.
Okay, and if a reunification counselor comes and says that she needs more time, would that impact trial at this point or trial dates?
It may. It's hard to answer that question again.
I would like to get that information across to the court and in front of you, Your Honor. I will be submitting that for reconsideration of trial dates, and that will be submitted today or tomorrow.
Okay, we have, I am going to pass this case to readiness. So if there are those type of issues, you can raise those at readiness. Currently, that is set for October 31st at 11:30 a.m. That is a Zoom hearing just like this, and it's the Universal Readiness Docket, is what it's called.
Yes, Docket. So as long as I file all of my exhibits by this date, I should be ready?
That is the hope, yes.
Okay, perfect.
And I failed to ask Ms. Looney any concerns as far as the state's concerned, or is the 31st and this week of the 6th still work for the state?
Those days still work for the state, Your Honor.
Perfect.
And Your Honor, is trial only on the 6th?
It's set for the week of the 6th. It looks like there's a request for it to be more than one day. So on the readiness docket, the week before is when you get the specific days of the following week that you'll be in trial.
Got it. And readiness docket is when the information by the reunification counselor will be assessed by the court to see if trial will continue?
If there is a concern there, that can be raised at that point in time. Yes, sir.
Okay. Thank you so much, Your Honor.
All right. Thank you. And we will pass this case on for readiness the 31st at 11:30.
Have a good day. Bye-bye.
And I guess I'll turn to you, Mr. Anagnostou.
Yes, my understanding is my client, he found, as indicated, an investor. They paid off the deficiency yesterday to, his name is, well, they paid off the deficiency to the attorney that is the trustee representing the foreclosing party. So the property is out of default.
Is there any documentation available just to confirm that that's the case? I haven't received anything or heard anything from the attorney representing the trustee.
So it was late yesterday afternoon when they paid it. My client is here. It's my understanding he got a receipt, maybe from the law firm. But beyond that, I was going to get documents today from the trustee.
Is that Mr. Daly?
Yes, that's what I was looking for. His last name, Joshua Daly. Thank you, Your Honor.
And we don't have any paperwork, nothing, other than Mr. Couch's word.
He may have a receipt.
Yeah, the receipt. Let's see, I don't know, this focus thing is weird.
When he
That is a receipt.
Yeah, when he made the payment, Mr. Daly had already left the office. It was like 4 o'clock yesterday before you could come up with the funds. So Mr. Daly wasn't there. But he had confirmed with him that if he made the payments, his staff would give him a receipt and they would stop the foreclosure.
Your Honor, what I would ask is that we just schedule a hearing for next week, pending just confirmation that this has happened. And if the hearing is no longer necessary because we have received that confirmation, we can simply strike it. But just for tracking purposes, I want to keep it on so my client isn't in a position to have to refile something to get it back before the court if that's not the case.
That's fine with me, Your Honor.
Mariah, Tuesday I think is closed, but can we open it back up to add this on? Let's do that. So Mr. Anagnostou or Mr. Couch, please do whatever you can to ensure there's some sort of proof that's sent to Miss Ward and her office before Tuesday. I will add this to October 24th, 2023 at the 1 o'clock docket. Excuse me, and we'll review. And Ms. Ward, if you get confirmation and you want to reach out and strike that hearing, even if we're too late to do it officially, I'll make sure to just do it on the record. Nobody would need to appear.
Perfect. Thank you so
I'll
much.
do that as soon as I hear confirmation, and that's fine if it's an email at 12:30 on Tuesday. I can still make that happen.
Okay, great. I'll just email your JA as soon as I receive some confirmation. Thank you so much.
Perfect. All right. Good luck. Thank you. Nobody is
Thank
in the
you.
waiting room. I did notice that you provided service. So I just wanted to confirm on the record that we still don't have Mr. Fisher. I do have all of your paperwork, the findings and conclusions, final divorce order, parenting plan, child support worksheet, child support order, and restraining order.
Okay. So I've given him notice. Her original petition didn't outline specific requests as it related to the allocation of property debts and spousal maintenance and attorney's fees. Those were all reserved for the court's determination. So historically, I've provided notice just as I did today. Even though he's been defaulted, had he appeared, he could have provided any objections that he had to these orders. So I think that by not appearing, he's acquiescing to what we've proposed. We had already ordered that the house be placed on the market for sale. She's been working with a realtor to get that ready. And so as you see in the decree, we're proposing that essentially he's going to receive 40% of those proceeds after reimbursement to my client for 50% of the payments of the ongoing mortgage, the bills to ready the home for sale pursuant to the realtor's recommendations and the like.
I appreciate that, Ms. McLean. I did review, I saw the proposals, I saw the breakdown. I noticed there were some differences, but given essentially the trajectory that this case has taken over the last several months, I think everything that's been proposed in your final orders is appropriate given the circumstances. So I'm going to sign off on everything as presented.
Okay, and I believe we also submitted to the clerk's office the law enforcement sheet for the an updated law enforcement sheet for the restraining order as my client's address has changed.
I see that there was a law enforcement confidential information form that was submitted on the 17th. It's not, I can't see it in Odyssey. It hasn't been scanned in yet, but it's been marked in there. I do have the restraining order. That should all work itself out. Is that correct, Brian? Yes. Okay.
Perfect.
I'm signing the last order now.
Thank you very much. We appreciate it.
Thank you. Have a good day.